and peoples of this country. Members of the board who are appointed in consequence of their membership or affiliation with any sport or recreation body must relinquish their membership or affiliation upon their appointment. Members of the board must serve no more than 2 4-year terms in their respective posts on the board. And the president of the board, because of the expected increase in responsibility, should be paid a monthly retainer. I underline not full-time, but a monthly retainer and all other members of the board should be paid for meetings that they attend, including board and subcommittee meetings. And in terms of the management structure of SASCOC should consist of, among other things, a CEO, a CFO, a COO, and a Director of Communications. In particular, each of these posts must be advertised and must be filled pursuant to a fair and equitable recruitment process by an independent committee. These appointees must not have any links with a sport or recreation body or must relinquish such links, if any, upon appointment. The appointments must be confirmed in a contract of employment on a fixed-term basis and subject to a probationary period, job description, and key performance areas. Chief Executive Officer must also be subjected to the direction and control of the President of the Board and the Chairperson of the Finance Committee. The Chief Financial Officer must be subjected to the direction and the control of the COO and Chairperson of the Finance Committee. The Chief Operations Officer must report to the Chief Executive Officer, and the Director of Communication must report to the President of the Board and to the Chief Executive Officer. Now, the interim measures that need to be taken by the current board. At the first meeting of SASCOC board, a process for the revision of all policies and procedures must be determined. Travel benefits and allowances for the president, members of the board, and the CEO should be discussed, and a process for the determination of such benefit should be decided subject to the approval of an independent external auditor. Administrative matters related to the operation of the board, including the holding of meetings, agendas, the distribution of minutes, and matters ancillary to the functioning of the board, should be determined on an urgent basis. Pending the implementation of the above recommendations, the following further recommendations are made. SASCOC must, pending the process set above, read and consider the Pullinger report and any other reports received pursuant to investigations conducted at its behest, and determine the appropriateness and the rationality of implementing some or all of its recommendations. SASCOC must appoint a national colors board in terms of the Act, its constitution, and internal regulations for purposes of determining any and all issues relevant to the awarding of national colors to athletes. For this purpose, the Minister, which is myself, has deemed the National Colors Board to have been in existence and will publish a decision to this effect in the Government Gazette in due course. And I've also directed that SASCOC regularize the National Colors Board in line with the existing legal provisions as a long-term solution The National Sport and Recreation Act Amendment Bill, which has been tabled before Parliament, has made provisions which provide a lasting legal remedy to this matter. SASCOC has to ensure that there is complete transparency, accountability, and consultation in relation to all decision-making processes. It has to ensure that international travel is limited and is in line with a revised interim policy, and that the procurement of services is approved by a subcommittee of members of the board specially constituted for this purpose. Also has to undertake a complete and thorough audit of its financial transactions for at least the last 5 years, including travel and other benefits and the procurement of services, and that any irregular or wasteful and fruitless expenditure is dealt with and, if possible, recovered. Investigate the payments made to the SS Griffin and ensure that all members of the board who received commissions payable to them from other entities declare the details thereof to the board for further investigation. On the representations received, I have perused and scrutinized the contents and viewpoints expressed by way of representations received from all key role players in relation to the report and the executive summary of the SASCOC Committee of Inquiry, and thoroughly weighed them against the recommendations of the committee. The role players at point here are SASCOC that made their submissions, Mr. Tabi Reddy, the International Olympic Committee, and the International Paralympic Committee. Insofar as the representations of SASCOC are concerned, in general, it is apparent that while SASCOC agrees with some of the committee's recommendations, it does not agree with other substantive recommendations that are, in the committee's view, fundamental to the governance of sport in the Republic of South Africa. And in essence, it is apparent from SASCOC's response to the committee's recommendations that SASCOC is opposed to any external or independent oversight of their roles, functions, and the use of public monies. In essence, SASCOC's representations reflect, amongst others, that SASCOC has commended the work done by the said Committee of Inquiry, subsequently fully endorsed all the recommendations of the committee in principle, save for the following reservations insofar as the executive summary is concerned. In paragraph 41, SASCOC concurs with the National Sport and Recreation Act 1998, hereinafter referred as the Act, that it must be amended as proposed by the committee, provided that such amendments must in essence be in harmony with IOC, IPC, the Commonwealth Games Federation, the Association of Olympic Committee, and the World Games. Our decision regarding the amendments to Act affecting the Constitution of SASCOC, the IOC, and IPC is that SASCOC's representation in this regard is approved as motivated later in this document in relation to IOC and IPC. In paragraph 42.2.1.1, although the committee recommended that a president of SASCOC must, amongst others, be a person who is independent, be appointed by an independent committee, and be a person who has no affiliation to any sport and or recreation body, SASCOC is of the view that the president must be elected by the General Assembly and may not serve in any national executive of SASCOC members as per SASCOC Constitution. Our decision regarding the appointment of President of SASCOC is that SASCOC representation in this regard is disapproved. I am of the view that SASCOC's counter-proposal effectively retains the current system of appointment and requires that the appointment of the President must be done through the General Assembly process and not by an independent committee. The General Assembly of SASCOC will be at liberty to designate positions of Deputy President and Vice President respectively. It will be proven that SASCOC should streamline its functions as a sports confederation and also those that it plays as a National Olympic Committee. To this extent, the SASCOC constitutional review process should take into account that perhaps it has to delineate these two work streams under the leadership of the President being supported by Deputy President on one side and the Vice President on the other side. Maybe getting back to the decision on the independent committee, I think it left not finalized to say we have therefore come to the middle ground in terms of that the independent committee would undertake in terms of its nomination processes with a nomination committee, propose names that would be presented before the General Assembly that then would elect the President of SASCOC. And in terms of paragraph 42.2.1.2, where SASCOC is of the opinion that the accountant must be appointed through labor law and HR policy and that such an appointment such appointed accountant must be an ex-officio member of the SASCOC board. The decision regarding the appointment of the accountant as ex-officio board member is that SASCOC representation in this regard is approved, subject to the principles of good cooperative governance as contemplated in the King 4 report, and such an appointment of an accountant be spearheaded and considered by an independent committee as contemplated and motivated in paragraph 42.2.1.1 above. Under paragraph 42.2.1.3, SASCOC is of the view that the commercial lawyer must be selected by way of a nomination process and must thereafter be duly appointed by a nomination committee as opposed to an independent committee as commended by the SASCOC Committee of Inquiry. Our decision regarding the appointment of commercial lawyer is that SASCOC's representation in this regard is disapproved based on the same grounds applicable to the appointment of the President of SASCOC, the accountant as an ex-officio board member as referred above. Under paragraph 42.2.3, despite the recommendations by the committee that members of the board who are appointed in consequence of their membership or affiliation with any sport and recreation body must relinquish such membership or affiliation upon their appointment, SASCOC has an opposite viewpoint in this regard. It is of the view that all SASCOC board members, not only president, accountant, and the commercial lawyer, should not be compelled to relinquish their membership or affiliation from sport and recreation body. Our decision, therefore, regarding the relinquishing by president and board members of SASCOC of their membership and affiliation is that SASCOC's representation is disapproved. I am of the view that SASCOC representation is totally at loggerheads with the good governance as the said SASCOC board members, inclusive of president, accountant, and the commercial lawyer, and must indeed relinquish such membership and affiliation as contemplated and motivated in paragraph 42.2.1 and 42.2.3 of the recommendations of the committee. I'm further of the view that SASCOC recommendation retains the status quo despite the numerous issues of conflicts of interest and commissions which plagues its board. However, I will make one exception to my above-mentioned decision in order to cater for special circumstances which warrant that a person, namely the president or a board member of SASCOC, will not have to relinquish his or her membership or affiliation to a sport or recreation body where such a person has been co-opted by invitation, inherently, automatically, or otherwise to serve on an international sport or recreation controlling body of which SASCOC is a member of or affiliated to. The final detail of this exception will be canvassed in greater detail with SASCOC soon. As it relates to paragraph 42.2.4, SASCOC recommends that the term of office of SASCOC board members must be regulated in accordance with the current SASCOC constitution instead of the committee's proposed term of 2 years for SASCOC board members so as to maximize consistency of a period of 2 terms. Our decision regarding term of office of SASCOC board members is that SASCOC representation in this regard is disapproved as it is more preferable to align the terms of office of SASCOC board members with a period of 2 4-year terms at the most. The assertion that consistency is achieved in 3 terms and not 2 terms is incorrect. 2 4-year terms amount to 8 years, which in any event create consistency advantages. As it relates to paragraph 42.2.5, whereas the committee recommended that the president of the SASCOC board, because of the expected increase in his or her responsibility, should be paid a monthly retainer, and all other members of the board should be paid for meetings that they attend, including board and subcommittee meetings. SASCOC is of the view that the retainer for the president must be based on international trends, that the current policy for attendance of meetings by SASCOC board members, etc., should remain in place as approved by the General Assembly. The decision regarding retainer and meeting policy is that SASCOC representation in this regard is approved subject to such a retainer being compliant with the approved travel benefit and allowances policy as overseen by an independent accountant. Such retainer be benchmarked with similar institutions in the Republic, like your state-owned enterprises, etc., and the current attendance policy of meetings be reviewed on an annual basis. With regards to paragraph 42.3.7, although the committee recommends that the CEO, the CFO, the COO, the Director, Communication appointees must not have any links with a sport or recreation body or must relinquish such links, if any, upon appointment. SASCOC is of the view that such appointees should not be compelled to relinquish their membership or affiliation from sport and recreation bodies. Our decision in this regard is that SASCOC representation should be disapproved. We want to reiterate SASCOC's recommendation that it retains the status quo without any justification at all, and is totally at loggerheads with the consistent recommendations provided by the committee in the above regard, which align with and conform to good governance as projected in the King 4 report. Paragraph 42.4.2. SASCOC Committee of Inquiry recommended that the travel benefits and allowances for the President, the members of SASCOC Board, and the CEO should be discussed, and a process for the determination of such benefits should be decided subject to approval by an independent external auditor. By contrast, however, SASCOC is of the opinion that the travel benefits and allowances policy of SASCOC must be annually reviewed and approved by the Remuneration Committee. Our decision, therefore, on the Withdrawal of Travel policy is that SASCOC's representation in this regard can be approved subject to the final approval of the independent auditor of any decision taken by the Remuneration Committee based on principles of reasonableness and affordability. Paragraph 43.3.7. Although the committee has recommended that SASCOC must ensure that all members of the board who receive commissions payable to them from other entities declare the detail thereof to the board for further investigation, SASCOC is of the view that they will only need to do so insofar as it relates to sport and recreation matters. The decision regarding this declaration of interest is that SASCOC's representation is disapproved. SASCOC is aware that a substantial number of incidences that came to the attention of the committee at its public hearings that also had an impact on or related to money payable to other entities. Henceforth, a declaration by the board members with an expunging effect to cover all commissions, including any other favor or advantage granted in return for something in kind, for that matter, payable, is therefore absolutely necessitated as it conforms to Section 75 of the Companies Act. With regard to the Pullinger report and the execution and implementation thereof, our decision is that I concur with the view of the committee that SASCOC must conform to the recommendations of the committee in this regard with immediate effect, and must furnish me with regular updated progress reports and the eventual outcome report insofar as the execution and implementation of the recommendations of the Pullinger report in accordance with the timelines as set out here under are concerned. With regard to the limitation of international travel in accordance with the revised interim policy as reflected in paragraph 43.1.4, SASCOC states that its board agrees with the recommendation of the committee and that such a policy is being implemented. Our decision, therefore, on the limitation of international travel is that I'm of the view that SASCOC's confirmation in this regard can reasonably be accepted as the implementation of the travel benefits and allowances policy is administered by the Remuneration Committee subject to a final approval of an independent auditor of any decision taken by the Remuneration Committee based on the principles of reasonableness and affordability. and therefore the decision is in order to give a significant substance and purpose to the final report with its recommendations following the consultation process recently executed with SASCOC in the above regard, I have in essence now decided to approve the final report and its executive summary, which contains the recommendations of the SASCOC Committee of Inquiry formally and fully, save for the few instances referred to above, which allow for minor deviations where applicable. Require of SASCOC with immediate effect to action and implement all the recommendations subject to the minor divergences referred to above where the representations of SASCOC have been approved. And of SASCOC Committee of Inquiry and in accordance with the timelines mentioned hereunder. And to grant SASCOC as from the effective date until 30th April 2019 to execute, implement, and fulfill all the said recommendations in the above regard, provided that SASCOC must provide me with an updated monthly report at the end of each month on its progress to execute, implement, and fulfill the said recommendations in writing, and that a suitable, independent, external, and neutral person or persons, like an auditor, a private lawyer, will be appointed by Sport and Recreation, specifically in this regard, with such monthly report as well, in order for him or her to champion and oversee the proper fulfillment, adherence, and compliance by SASCOC with the implementation and execution of all the recommendations of the committee as contained in its report and executive summary. It is envisaged that such an administrator will serve as a key liaison person with SASCOC on the implementation of these recommendations, and ministerial directives will be appointed and commence with the functions in mid-January 2019. Decisions regarding timelines. With regard to the said timelines, I expect SASCOC to comply with the said recommendations as follows. Insofar as all recommendations pertaining to SASCOC board and its management structure are concerned, we are giving the timelines of the end of April 2019. Insofar as matters that require immediate attention by a newly constituted board are concerned, all recommendations should be implemented from the first meetings of the newly constituted board and thereafter by the process agreed to by that board. Insofar as the interim measures to be taken by the current board per the recommendations of the committee, these recommendations must be implemented immediately. Should I, however, not be totally satisfied with the execution, implementation, and fulfilling of the recommendations of the committee by SASCOC, alternatively with the timelines and the speed with which SASCOC executes, implements, and fulfills its mandate in the above regard, I hereby reserve my following right, namely to issue a directive in terms of Section 13, subsection 5A of the National Sport and Recreation Act, Act number 10 of 1998 as amended, in terms of which I will action and implement the necessary intervention measures as provided for in the Act in the best interest of sport and the public as a whole in the country. And our decision regarding representation of Mr. Tabi Reddy, I have taken note and considered the representations received from Mr. Reddy were relevant, necessary, and deemed appropriate. With regard to the termination of his services at SASCOC, I am, in terms of Section 13, subsection 5B2 of the National Sport and Recreation Act, Act number 10 of 1998 as amended, debarred to interfere or to get involved in this matter as it relates to the termination of services of an executive member of a sports body, which in any event is a labor matter. I urge SASCOC that if indeed it has found misuse of funds on the part of Mr. Tabi Reddy, to actually do all in its power and authority within the feasible and reasonable limits to recover such funds. Regarding the decision on allegations of financial impropriety and mismanagement, I've decided, owing to the fact that the Ministerial Committee of Inquiry has not delved deeper into the financial affairs of SASCOC, and also having noted the mooted suggested course of action tasked and mandated the Director General of the Department of Sport and Recreation South Africa to refer any matters where there is prima facie case to be answered to the appropriate and relevant law enforcement agencies of the country to further pursue those matters within the framework of our criminal and civil law. Such referrals, if any, should be done by January 2019. Our decision regarding representations of IOC and IPC, in essence, the IOC and IPC advised that, in essence, needs to be consulted. It needs to be consulted to have any substantial amendments of the SASCOC Constitution based on the following, amongst others. 1, the implementation of the final report and the executive summary of the SASCOC Committee of Inquiry would require that SASCOC will have to consider a revision of its current constitution. Secondly, that such a revision will also require prior consultation and coordination with IOC and IPC to ensure full compliance of the proposed amendments with the Olympic Charter or IPC rules and regulation and the basic principles of good governance, amongst others. I am therefore of the view that the responses of the IOC and the IPC in this regard should be noted, respected, and accommodated accordingly. I'm very glad to inform you that Mr. Gideon Sam has, after discussions with him earlier on this morning regarding my stance in relation to SASCOC's counter proposals as referred above, advised me that SASCOC will align itself totally with my stance and will ensure the necessary steps are taken with immediate effect to address these issues in accordance with my stance. For this, Mr. Sam and the SASCOC board must be applauded, as it will go a long way to bring sufficient and effective closure in relation to management and governance issues that the committee and SASCOC, for that matter, have been embroiled and embattled with. I take this time, therefore, to thank the committee that has set aside time, dedicated its time, and assisted us with the recommendations that we think would put back our structure into a proper way in terms of governance of sporting events, and we take South Africans forward as a winning nation and as an active nation. Thank you very much.
Thank you very much, Minister, for that. Colleagues, we'll then enter on the question and answer setup. Please do assist me by providing your name as well as the institution that you represent. By show of hands, I will then know process. Oh, Sarai. be number 1. Number 2, number 3, number 4. Okay, let's deal the first round as such.
Not board members.
Yeah, not board members for the media people. It's for the media. Okay. The number 2 can be number 1. It's yourself, and then it's Ronnie after that. Who will take us? After you, Sneh?
Sorry, I just snuck in a bit late.
Does this work? Yeah. Cool. Sorry, I snuck in a bit late, so maybe this was addressed at the start. I just want to know from the Minister, what took so long for the report to be released? The reasons.
Just provide me the name in this question.
Sorry, Orchid Villiers from Independent Newspapers.
Shonin Timkuli from ENCA. So just in a nutshell, can we have a summary of then what happens to the President and the SASCOC board as well?
Number 3.
Charles from Media 24, Daily Sun and Sunday Sun. The Minister said something that if SASCOC don't compile with her recommendation, she'll have to take steps. Was it possible, did she ever think of putting them under administration or dissolve the board? And the members of the opposition parties, like the DA, there were reports that they walked out because the minister took time to release the reports. Now that she's released the reports, how does she feel now?
Okay. I think that's the first round. The President of Minister.
Thank you very much. As I indicated, that when we instituted the report, we wanted to make sure we have a functional body, and the essence is to make sure that the body gets back to function. Those processes, for instance, from the inception or the start of the whole process, the committee had to find time, sit, come up with recommendations. So that cycle took up to end August, and we received the report. Processes internally and in terms of issues of administrative justice require that if any member or associations get to be implicated in the report, they then are given an opportunity to also reflect on such. So we allowed that process. The bodies that I indicated that had to be consulted, including your IOC, your IPC, people implicated in the report, including SASCOC board. They had to be given time, they had to convene and then make inputs into to the department. And after considering such inputs, then the minister then determines what actions, because it's not a matter of just receiving the documents, as it is the comprehensive report and the summary, and then you issue it out. But responsibly, it is to say what action has to be taken. So that process went on until we are here today, that we are releasing the report for the public to also see the work that has gone on with the actions of what needs to happen moving forward. So that is the whole process as it took place before. I will perhaps combine that with the third question that gets to have DA working out in Parliament That was not a parliamentary inquiry report. It was a ministerial report, say departmental report, and therefore we are dealing with our own internal processes, and therefore we are available to the committee when we finalize those to brief the committee. So, and up to this stage, we also, as we're handing over, we're releasing this report today, had also the courtesy of also giving members of the committee the report, because it's open now for public. So if the committee requires us to appear before them to take them through on the different aspects of the report, we are available. So up to this process, where we are together with the SASCOC board, they hear what we are looking at them to implement, and the final report as we today have approved. That is the process now in terms of such engagements with any of the stakeholders, be it the media and whoever else in South Africa. Well, we could not put the cart before the horse by putting them under administration, because we had to get into every detail of understanding what was happening, what were the representations, what in each of the aspects has to happen. As I indicated earlier, I haven't gone through into each and every one of the recommendations as were the representations that we got, both from individuals and associations that presented. But those are matters in terms of implementation of the actions that need to be dealt with. Where SASCOC has not dealt with issues, for instance, of the Colours Board, we have an action that has to be taken into action, where they have dealt with in matters of dealing with their management. They have a responsibility to take steps and deal with such matters in a proper way. So here the processes, as I indicated, can only when they are not affecting the final recommendations or the final decisions in terms of what we have presented here, that we can look into the next steps in terms of further directives. And summary of what happens to the current board of SASCOC, I think tomorrow they will be in a proper space to get back to look into this final report as is presented, because the initial report which contained the recommendations of the committee were presented before them. They made their inputs. Today they are receiving, as this board, they are receiving, and therefore they are going to get back and deal with each of the recommendations. That is the situation at the moment.
Thank you very much, Minister. I don't know if there is any other bit I don't want to close. Xasa, we are the only one. And then we have to end the talk now. And we do number 3. Okay. That's the last one. Or last set of ones.
Yes. Minister, just 2 questions. Very young from SABC. During the hearings, one of the things the committee kept on referring to was the amount of time that is spent on discussing disputes than advancing the interests of sport in the field of play. Is there a matter that is concerning you, and could this be maybe the reflection even on the members of SASCOC? And also, Minister, there was also an allegation of sexual harassment that was dealt with even during the hearings. And we since also came to understand that there's a latest allegation of sexual harassment
at SASCOC that is alleged to have happened during the Youth Olympics. Does this concern you, especially during this period of the activism against women abuse?
Thank you very much. Number 2. You are number 2.
I'm Marizalki from Media 24. Minister, you require that all board members serve 2 4-year terms from now on. So what will happen to those currently serving in a 3rd term? I think there are 1 or 2 of them. Would they be asked to step down immediately? And then also, do you have a timeline for the appointment of new CEO and CFO, or will you let that SASCOC deal with that?
Tokozile Xasa, SABC News. Minister, you talked about Section 13 Act 10 of the 1988 Sports and Recreation Act. Will you please maybe just briefly, in detail, just maybe briefly say what it entails that you say you'll do according to that act when and if SASCOC does not comply with the recommendations of the committee?
Okay. The team here will also come in. Indeed, when the commission had to be established, it was the concern that indeed there was much more amount of time spent on dealing with disputes, some of them even ending up in court, and therefore taking away the money that is supposed to get into the actual work that SASCOC is supposed to be seized with. And therefore, when now the proposal in terms of the structure, it is seeking to put together mechanisms that would deal even with disputes, so that there is a focused attention that is put there, whilst on the side of it, as SASCOC has to go back and look into its own structure, there would be dedicated committees that would look into specific aspects, and therefore it does not blur the kind of roles and responsibilities. And already in terms of the amendment, in terms of the current amendment that is before Parliament, we also are seeking to clarify the roles of the department, SASCOC, and also put up a very clear dispute resolution mechanism that would assist even the rest of the federations moving forward. So that in itself, therefore, is saying, with the work that the committee has been seized with, dealing with the situation as it pertained previously, we're giving the opportunity to SASCOC to regularize and regulate and also, shape themselves to move along towards making sure that their constitution, their structure talk to that. That is why we are giving this whole process the timelines that I have indicated, that they have to go back, they have to sit and tease out in each of the recommendations, make sure that they are in line with that, whilst in the other angle we are dealing with the amendment of legislation. So fortunately, for some of the recommendations as they would pertain to Sport and Recreation Act, they have been incorporated into the amendments that are before Parliament now. Indeed, I think when you get into the issues of sexual harassment and how the matters were dealt with, the committee has made findings and recommendations as to how SASCOC did not deal in a proper way with the matter. and such that that matter continues to be part of what SASCOC needs to get back and deal with and finalize. So we've given it to SASCOC. We are not here to take over to do what they are supposed to do. We expect SASCOC to do what they are supposed to do. It is when they are not doing it that we will then come in. The matter on the Youth Olympics and the sexual harassment has not yet been brought to my attention. I will follow up because the only one that was before the committee was as it pertains to one of their employees. Yes. So, and how SASCOC dealt with that matter, which finally constituted one of the issues before the charges against their former CEO. The report that I presented captures what needs to be done in the immediate, as well as what needs to be done in terms of SASCOC restructuring in order to incorporate the kind of recommendations and focus that it needs to do, and also the capabilities and capacities that it needs to put in place in order to have the proper governance of the body. So that in itself is saying as they would be implementing the resolutions, the report that we are presenting today, it begins to say there are things that they can do immediately, there are things that would then be set. So it entails a process that we are giving them this time. So that in itself indicates to the meeting here that SASCOC board as it is remains and exists as SASCOC board that needs to take back this report and implement and report to us within the time frame. So in terms of what is in their current constitution, as well as to what extent that impacts on or is impacted upon by this recommendation, they are going to get back to us in terms of implementing such. So we'll be receiving reports for them to feed us on a monthly basis up to until the period that has been stipulated in the report. And in terms of the Act, DG, you can come in on both the existing as amended, plus also what we have proposed in the amendment.
Thank you very much, Minister. Section 13 of the law deals with the powers of the minister to issue ministerial directives. The directives can be broad and wide, obviously subject to the compliance with the principle of justice and the new provisions as set out in the Administrative Justice Act. That in itself means that minister may be able to issue a whole host of directives. Amongst them, some of them provided also in the law, is the withdrawal of funding as a key mechanism to force compliance. Minister may decide that she doesn't grant funding. She may also decide to withdraw her concurrence for the colours, and which means that then the protea being the key symbol of the Team SA and national teams that represent, because it is the transference of that colour to the team to say that now it is a South African team. If it is withdrawn, the colour, then
legally speaking, the team cannot be a South African team. It may be a team from South Africa, but it's not a South African team. And I think that there's a distinction there between the two. I'm sure you'll remember the story of the readmission to the Olympics when the agreement with the IOC on the national colors, with the Springbok being in dispute, was concerned, and the South African athletes ran as athletes of the IOC and with the Olympic banner and the Olympic flag. So there are those arrangements that normally gets made, but that's another measure. The other measure is the withdrawal of consent in terms of the bidding and hosting regulations. The minister may decide that he doesn't approve or doesn't provide any support towards bidding for international events or hosting of any international events within the Republic. The other measures that are there are all those that obviously concern the powers of the minister from a political premium point of view, where you know that typically most of the sponsors indeed require ministerial concurrence as well as support for them to ensure that their funding and their sponsorships are safe with federations. And typically she would not grant her confidence, so to say, in this regard. But there are other directives minister may issue that are available in terms of the remedies available within other provisions of laws and the edifice of our legal system. For instance, minister may order a forensic audit, may order an investigation be conducted, may order several disclosures, he may order and issue practice notes and things like that. So those are already remedies available within the legal framework, and when she issues that, she would issue it under the provisions of section 15, which says that she may issue such a directive to ensure compliance with that directive in the best interest of administration of sport. So I'm just summarizing it, but I think it will be helpful for you to actually read the section 30 and read the actual provision. It provides her with wide-ranging powers that she may exercise at her disposal.
Thank you very much. Thank you very much, Minister. DM, members of the committee.
Madam Minister, Deputy Minister, I think firstly, when I got a phone call, I think it was October last year, to sit on this committee, I wasn't sure whether I should accept this responsibility, particularly at this stage of my life. And I did consult people and I accepted it. And I'm very glad that I accepted it. It's been a long, arduous process. It's taken more than 12 months. But really we've had a fantastic committee. Unfortunately the chairperson is not well, but Shamima here on my left is a Labour lawyer of note. Her questioning was extensive, her thoroughness was outstanding, and Shamima, I'd really like on behalf of everybody to thank you for your very important contribution to the success of this project. Secondly, I met the current minister for the first time in Bloemfontein a couple of weeks ago. And about 10 days ago, we were asked to meet with her, and we spent about 4 to 5 hours. And I'm not saying this because the minister and the deputy minister has approved most of our recommendations. It's got nothing to do with that. One had to be impressed with her knowledge of the problem, the understanding. She was very thorough. She went through all our reports. She had her own ideas, and I have no doubt that our Prime Minister, our President, has really made an excellent appointment with the current Minister. The last thing I would like to say is that, in essence, what we've tried to achieve here is, in simple terms, and we don't want to categorize any individual person, but I think what it's about the way forward, because sport in this country is very important to all its people, black, white, young, old, doesn't matter where you come from. We are a sport-loving country. And I think what we try to create is, in essence, good corporate governance, openness, accountability, and fair processes. That's what it's about. And if the new SASCOC board implements all that, I think sport will really thrive and relish what's awaiting them in the future. And just lastly, I know Gideon for a long time. Gideon, how long have we known each other? I just want to just want to commend you what the Minister said for accepting these recommendations on behalf of your board. And I think sport today is in a much better frame of not only mind but in spirit that we've had for a very long time. Thank you, Minister.
Thank you very much. Thank you very much, Doc. We'll have one-on-ones from the outside, and then there's some small light lunch. I think we get that. I'm not sure if can we have the one-on-ones outside, because I understand that there's another media presentation happen.